Looks like we're live already and it's begun. So, Isabel, why don't you go ahead?
Are we ready to go? Good. So good morning, everyone. Thank you. Let me start by thanking the conveners of this conference, especially the Tyndall Global Law School and Kabarak University and the African Society of International Law. Thank you so much for having us all together to discuss this interesting topic. We live today a very exciting momentum with respect to climate change and the emergency it is creating. As you all know, 3 advisory cases are now pending before international jurisdictions. The December 2022 request before the International Tribunal of the Law of the Sea from the Commission of Small Island States on Climate Change and International Law. This case regards the obligation of state parties to the United Nations Convention on the Law of the Sea, UNCLOS, with respect to climate change. The second case that is now pending is the application filed by Chile and Colombia in January 2023 before the Inter-American Court of Human Rights on the legal obligation of states parties to the American Convention on Human Rights to respond to the climate emergency in the individual and collective capacities. And last but not least, the UN resolution of March 2023 on the regarding the requests of an advisory opinion of the International Court of Justice on the obligation of states in respect with climate change. In parallel to these 3 advisory cases, we also have the European Court of Human Rights that is currently examining 3 contentious cases on various aspects of the legal obligations of state parties to the European Convention on Human Rights and Fundamental Freedoms. So the main question that gathers us today is what is at stake for the Global South? Let's keep in mind maybe a few pivotal elements to answer this question. The Global South is the part of the world that is the least responsible for greenhouse gas emissions, but it is the most impacted by climate change and the prime victim of its rapid and devastating effects. And finally, the Global South is the least financially equipped to face and prepare for climate change effects. International law for now lacks clarity and responses with regards to climate change, and the coming positions that will be taken in the advisory cases will help address this issue, and more precisely the one of the state's obligations. Our distinguished speakers today will help us identify the challenges of these issues and understand how international law will address climate change and its direct and indirect consequences, along with the crucial question of possible fragmentation of international law. Let me give the floor to Professor Rashmi Raman from Tyndall Global Law School, who will introduce the webinar and tell us a bit more about it. Thank you very much.
Thanks very much to our esteemed moderator, Isabel Rouche. It's a pleasure to have you. And welcome to all attendees. A special welcome to our distinguished panel. We are delighted that we were able to pull together experts on this topic from all over the world, and that this webinar format has also allowed us to collaborate with the African Society for International Law, the Kabarak University Press, and the Center for International Legal Studies at the Jindal Global Law School, to which Gudmundur and I belong. So we're all represented here, the 3 co-hosts. I just want to start with telling you a little bit about how this idea came into being. Humphrey Sipala, who's here, my co-convener, and I, we were chatting about what a momentous thing we are witnessing suddenly with 3 applications for advisory opinions, all of which originated discreetly and followed very different pathways, but actually are about more or less the same set of obligations under question in international law, placed before 3 very different forums. And what struck Humphrey and me was the complexion of the 3 courts. How the International Court of Justice, which is so different from the International Tribunal for the Law of the Sea, which in turn is again different from the Inter-American Court. How these 3 bodies choose to respond to these 3 requests for advisory opinions will now shape any conversation on climate change obligation in the years to come. And we are really at a cusp right now where written submissions have been invited by some of these courts from states parties. And so Humphrey and I, who are situated in Kenya and in India, respectively, we thought, well, what kind of South-South collaboration can we do meaningfully to try and engage intellectually with the possibilities that this crossroad presents in international law? And that's how this idea of having a 2-part webinar was born. This is the first of those parts. And I'm so glad that Nyanje from the African Society of International Law, who is here with us today, was able to help us by providing contacts, a forum, and the support of the African Society for International Law. We're so grateful. I'm also so grateful that we were able to get Professor Okowa, Professor Erickson, and Professor Mbenge. Unfortunately, Professor Venske, who is also one of our panelists, was unable to join us because of poor health. But we hope that he will be here for the next iteration. There will be a second iteration of this webinar in the end of August. And between now and the end of August, Humphrey and I, together with our co-conveners, hope to generate a series of posts where we take the content of these webinars and try and create dialogue and discussion. This will be completely free. We are hoping to do a really easy, accessible blog posts where everybody can have access to them. And we hope that this will generate critical momentum and energy in states, especially states that are in the geographical global south and also in the intellectual global south, to try and mobilize critical capital in every sense of that word to contribute submissions before these 3 courts for all these states. And really, this is our attempt to try and get more voices heard and to put out an open plea to engage more with all of the courts and to engage more with international law, because all of us have a stake, as Isabel has so beautifully explained, in the topic that's before the court. This is something that affects all of us. And with that, I hand the floor over to Humphrey, who will now explain a little bit more about what we are going to do. I'm conscious of the time, and I don't want to take away from the speaking time of the panelists, so I want to keep it really short. Thank you once again.
Let me mute myself. Thank you very much to everyone who's here. I'm quite excited and thankful to be part of this endeavor to spark conversation about how do we as Global South scholars engage with the thinking and spur our states to participate in international lawmaking as is present for us in these advisory opinions. I should quickly really, again, I'm so happy to be here and honored to be here with first my Law of the Sea professor, Professor Eriksson Gunmundur, as you insist that we call you, and also to Professor Makan, Professor Koa, and to our colleagues from AFSEL, my partner in crime, Rashmi, one of the many things we try and put together. So my brief here is really to do a quick overview of what have been the participation of Global South states in advisory opinions before the international bodies. Here, basically, the most history is with the ICJ, obviously, because of the years. As I'll come to it, and as we know, ITLOS has only had 3 requests, 2 of which are out, and the 3rd is the one that is the object of our conversation. But I should mention one thing. I should actually also mention, just before I spoke to Rashmi, this conversation was actually spurred in me by one of my former students who is among the attendees, and I must thank you, Kariuki Kanyiri, who is one who spurred me and said, wait, but what are we doing as Global South states? And I thought, well, actually, we should do something. So thank you, Kanyiri, for always pushing your teacher to think, and I appreciate that. So I hope you can see my presentation. I hope it's all visible in the share, or should I? Okay, let me reshare again. Okay, I say yeah. I hope we can all see this. Okay. Let me start by saying, so what is our definition of Global South states? I think for obvious reasons, it excludes the WEOG group at the UN. And so we think of this as the Africa group and the Eastern European group as well, which consists of 23 other states. So all the statistics that you'll see quickly are really about the Africa group, GRULAC, and the Asia Pacific, with the exception of Japan and I think Korea. One thing we did not do in this research, and I must thank my research assistant, Patricia Chiruyot, for helping me cobble this together, is that we didn't look at the quality of submissions. We were just asking ourselves who responded to the request by the courts to submit written statements and maybe make oral submissions. So the highlights of the finding are these, and I hope you can follow through. So first, let's start with the ICJ. Only 9 ICJ advisory opinions have received more than 3 Global South states submissions, either oral or written. Only 9. 15 others have received some submissions, but between 1 and 3 states. And again, this is both oral and written. And then 5 advisory opinions from the ICJ, including from as late as 1989, on the diplomatic immunities of special rapporteurs through the 1950s, received no participation whatsoever. So I'll just quickly run through them. So advisory opinion, the Chagos case, I think, again, if there's a case that one could say is emblematic of the condition of the Global South and the assertion of Global South, or let's be heard, it is Chagos. You can see this is it's not the overwhelming that statistic that I thought I would see from the Global South. The other is Kosovo. One could say, oh, the politics around this may not have inspired many African states, for instance, because there's quite a paucity of African states submitting in this regard. The third, Palestine war. Considering the context in which the African Organization of African Unity, for instance, and has participated in thinking about the occupied Palestinian territories, again, the submission is quite low. There's quite a bit from the usual suspects, but not anything new. Nuclear weapons. In the nuclear weapons opinion, again, you can see written statements from Colombia, Costa Rica, India, Iran, Malaysia, Nauru, Samoa, Solomon Islands, Sri Lanka, and Uganda. One would have thought maybe a bit more, but then again, so I'm just going through this so that we can get a glance of the breadth of states that could be participating and are not. This is the advisory opinion of 1980 on WHO and Egypt. Again, the usual suspects, not much. This was one that I thought gave me cause for pause. Western Sahara, 1975. Again, a case that we in scholarship cite with some exception that this is emblematic of the African condition, and again, not much participation from the African states, hardly any from Asia, a bit from Latin America. The primary case, I think this was a bit of a heartbreak for me, I must say, the 1971 Namibia Southwest case. Now, in context, I mean, the fact is, at the time of this advisory opinion, the Ethiopia-Liberia cases had gone bottoms up, as we know, and there was quite an active rebellion from African states at this time of the ICJ. But then, as you can see, quite a paucity of submissions. So I'll just quickly run through to the ones that have received little or no engagement. I'll just quickly pose these for us to glance at. As you can see, there are 15, so that it shows again that the majority of the advisory opinion requests that came out have not been participated by the Global South to some significant extent. Now, at this point, I'd like to pause. So here we're going down the years in 1956, 1955. You can see the advisory opinions, we're already in the 50s. So this is before the wave of decolonization of the 1960s. And one of the things that strikes me is that even though this is in the late 1950s, the Bandung Conference has already occurred. And so this was, and the Bandung Conference, as you know, was a state conference about decolonization. So it is true that much of what has come out in the Law of the Sea Convention, particularly the African-Asian, Afro-Asian Consultative Legal Forum, came out of this move by Global South states, particularly African Asia, to have an alliance of thinking around, and an underlined movement as well was in part born out of the Bandung spirit. But it shows that it did take a while for the states to actually begin participating. And for me, these quick look through at the statistics do indicate to me that there is quite a gap between, and I think this is what our panelists will speak to, quite a gap between the state will, the widespread acceptance, even in state conversation, pronouncements around the right of Global South states to be heard, and the actual participation in the legal processes. And I think this is precisely the mechanics of this, the dynamics of this. What makes it not work is part of the reason why we're hoping to engage and spur the conversation. Again, ITLOS has only had 2 earlier advisory opinions. And again, so from the second advisory opinion is particularly interesting, considering who filed the request. Written submissions came from Saudi Arabia, China, Somalia, Micronesia, Argentina, Chile, Thailand, Cuba, and Sri Lanka. Yes, I don't know. So this is some of the stuff that I think we need to chip out and question ourselves and see how best we can. I think it's one of those legacies of the Global South states participation in international law, which we would like to reverse and certainly improve on. So that concludes my brief quick through of what has been our history with participation in these cases. I'd just like to mention for the Inter-American Court, the only 2 WEOG states are Canada and the US, and they do not participate in the Inter-American Court proceedings. at least, and not little, at all, because of, and especially the US not having ratified the American Convention. So that's where we are, and I think it sets the basis for our conversation. But yeah, over to you, to Isabel, the moderator. Thank you. I'll stop the share now.
Sorry, I was struggling unmuting myself. So I understand that, thank you very much. I understand the next speaker is Makan. Professor Makan Beng is Professor of International Law at the Faculty of Law at the University of Geneva. And he's Director of Department of the International Law and International Organization. He has acted as expert for the African Union, the Secretary General of the United Nations, and the United Nations Economic Commission for Africa, the United Nations Environment Programme, the Office of the High Commissioner for Human Rights, the World Health Organization, the World Bank, and many other organizations. He has served as counsel in disputes before international courts and tribunals, and in particular before the ICJ and investment cases, and as advisor for governments. He is involved in the negotiations of several international investment agreements in Africa, and he is, since 2017, the distinguished president of the African Society of International Law. Makan, the floor is yours.
Thank you so much, dear Isabel, and good afternoon, good morning, or good evening to everyone. It's really a pleasure to be here and to have the opportunity and privilege to participate in this very important and timely webinar. I would like, of course, to thank very much the organizers, and in particular my dear sister Rashmi and my dear brother Humphrey, and also John for the invitation. Allow me maybe to start where you have finished, my dear Humphrey, on the engagement of the Global South in advisory opinions. I think that it's important here to emphasize that there is today a new trend. There is today a new trend, and that new trend is that we are seeing more and more Global South countries or Global South institutions triggering requests for advisory opinions with respect of issues of common interest in the field of the protection of the global environment. I think this is something that is very important to emphasize, this new trend of Global South countries, Global South institutions triggering requests for advisory opinions with respect to issues of common interest in the field of global environment. And when it comes to ITLOS, for instance, let's not forget that the very first advisory opinion that ITLOS had to deal with was actually triggered by West African Fisheries Organization, the Sub-Regional Fisheries Commission, which is composed of 7 West African states. It is that organization that is behind the advisory opinion that was rendered by the International Tribunal for the Law of the Sea in its entirety in 2015. So we are now in a new era where Global South engagement is more proactive, is more active when it comes to the protection of the global environment. And what is going on right now with the 3 requests for advisory opinions on climate change are, in my view, a confirmation, a consolidation of such a trend. The request for an advisory opinion on climate change before the International Court of Justice was triggered by Vanuatu, a small island developing state. And let's not forget that Vanuatu was assisted by 18 champions, what we call the champions. You know, in the UN, they have this tradition that there's always champions that are helping behind requests for advisory opinions. And among the 18 champions that have supported Vanuatu, Humphrey, you had 5 African states, Sierra Leone, Angola, Uganda, Morocco, and Mozambique were among the 18 champions that helped assisted Vanuatu in being successful in having a majority of the UN General Assembly supporting the request for an advisory opinion before the ICJ on climate change. I'm not going, of course, to remind us though that the request for an advisory opinion on climate change before the Inter-American Court on Human Rights was triggered by Colombia and Chile. So 2 Latin American states that are part of the Global South, they are the ones behind that request. And then last but not least, the request for an advisory opinion on climate change before ITLOS was triggered once again by the Global South. That advisory opinion was triggered by what we call COSIS, an institution that we call COSIS, the Commission of Small Island States on climate change and international law, which was created in November 2022 during COP26 in Glasgow. November 2021 during COP26 in Glasgow. This is when the agreement for the establishment of COSIS was actually concluded by Antigua and Barbuda and Tuvalu. These were the 2 states that concluded this treaty that has established COSIS. And this COSIS agreement is very innovative, is very pioneer. Why? Because COSIS is the first international organization that has been created by Global South countries, by small island developing countries, that has been created to promote the development of international law in relation to climate change. Now, that's the first international organization that was specifically created for the development of rules and principles regarding the international law applicable to climate change. And what makes the agreement establishing COSIS even more pioneer, even more innovative, is that this agreement also emphasized that the development of the international law relating to climate change would have to go through the jurisprudence of international courts and tribunals. Personally, I have never seen the constitutive act of an international organization that emphasizing that recourse to the jurisprudence of international courts and tribunals would allow to develop international law in a given field. And so this innovative mechanism, this innovative machinery of COSIS is again the product of the Global South. So I think it's important to emphasize, you know, the new trend in which we are, and the new trend that is showing that the Global South has now decided to be rule makers, or at least to be leaders in developing the use of advisory opinions, or the use of the case law of international courts and tribunals in order to develop rules and principles when it comes to climate change. So I was now just mentioning the COSIS, the COSIS agreement. And I know that one of the topic of today's webinar is whether having several requests for advisory opinions going on at the same time, whether this can create, or this may create fragmentation. You know, my point of view is that actually the COSIS agreement has been has been vector of what I would call procedural cross-fertilization. You know, quite often we international lawyers, when we look at how international courts and tribunals interact, we insist a lot on substantive cross-fertilization. So basically, how do they inspire each other from a substantive point of view? I think that what we are witnessing now with these 3 requests for advisory opinions that we are discussing today, what we are witnessing is a new wave of cross-fertilization that I would call procedural cross-fertilization. As I was mentioning, the COSIS agreement is actually emphasizing that using the jurisprudence of international courts and tribunals, and in particular requesting advisory opinions, could contribute to the development of rules and principles in relation to the international law applicable to the fight against global warming. And this trend or this wave that has been set by the COSIS agreement has actually led to other requests for advisory opinions being submitted. And this is why I'm talking about procedural cross-fertilization. Let's remember that the request for an advisory opinion to the ITLOS, so the one triggered by COSIS, was submitted in October or November 2022. Then right after procedural cross-fertilization, January 2023, we have Colombia and Chile requesting an advisory opinion to the International Court of Inter-American Court of Human Rights on climate change. And then few months after, in March or April 2023, we are having the request for an advisory opinion on climate change before the International Court of Justice. This is again for me what I call the procedural cross-fertilization that is happening now, rather than fragmentation, at least no procedural fragmentation, but real procedural cross-fertilization. I know that some of the colleagues here would tell me, yeah, but you know, the Vanuatu initiative for an advisory opinion before the ICJ on climate change has been here for many years. But I personally believe that that what has been done by COSIS, the possibility for COSIS to request an advisory opinion to ITLOS on climate change, has been a facilitating element, has been a facilitating factor to actually convince later on a broad majority of UN member states to support a request for an advisory opinion on climate change before the International Court of Justice. So what we are witnessing today with these 3 requests for advisory opinion is what I would call procedural cross-fertilization. And it's very interesting. It's very interesting. Why? Because such cross-fertilization has already happened, but as I was saying, more from a substantive point of view, than from a procedural point of view. If you pay attention, this has already happened. Why? Remember that in 2010, the International Court of Justice, in a contentious case, in the famous pulp mills case, rendered a judgment. So it was not an advisory opinion, it was a judgment. But the judgment of the International Court of Justice in the pulp mills case was very interesting because it was setting interesting developments regarding environmental protection. So regarding, in particular, due diligence when it comes to the protection of the environment. And then what did we see after that? What did we see after that from a substantive point of view? 2 years after pulp mills, the deep seabed chamber of ITLOS rendered an advisory opinion in 2012 on responsibilities and obligations of state sponsoring activities and entities in the deep seabed area. And a lot of what has been developed by the seabed chamber in that advisory opinion was actually building upon what the International Court of Justice said in the pulp mill case in in relation to due diligence, the conduct of environmental impact assessment, etc. So we have witnessed that substantive cross-fertilization at that moment. And then 5 years after the advisory opinion rendered by the Deep Seabed Chamber of ITLOS, the Inter-American Court of Human Rights rendered a very pioneer advisory opinion. Many are forgetting, are overlooking that. But in 2017, the Inter-American Court of Human Rights rendered a very pioneer advisory opinion on the relationship between the environment and human rights. And that advisory opinion of the Inter-American Court of Human Rights was actually rendered upon request of Colombia. So it's not the first time that Colombia is contributing to the development of general international environmental law. And if you read carefully the advisory opinion that was rendered by the Inter-American Court of Human Rights in 2017, you will see that the Inter-American Court on Human Rights built a lot of its reasoning on the basis of what was said in pulp mills, what was said in the advisory opinion of the Deep Seabed Chamber, in particular, again, in relation to due diligence and in relation to the status of the precautionary principle. So we've been witnessing, when it comes to environmental protection, already cross-fertilization from a substantive point of view that shows that we are going more into harmonization or coordination of international law. We are going more into some sort of harmonious development of international law than fragmentation of international law. And this is why I believe right now, this wave of procedural cross-fertilization when it comes to requests for advisory opinions on climate change should be seen as a positive move and not as a negative move or a risky move that would fragment the international law applicable to climate change. Now, to finish my intervention, I would like to emphasize maybe what I believe could be the opportunities, the opportunities for the global South, or at least what global South countries should or institutions should push for to avoid the risk of fragmentation or to avoid, you know, diverging interpretations in the context of these requests for advisory opinions. For me, there are two aspects that I think will be important to push forward. And they are linked again to the procedural cross-fertilization, which in my view should lead to some sort of procedural coordination. So the first aspect I want to emphasize, what I would call enhanced committee. Enhanced committee. I think that these three pending requests for advisory opinions are actually a very good momentum, a very good opportunity to foster enhanced committee. We know committee, now I'm talking about enhanced committee. We know that each of these courts have, each of these courts that are dealing with this request for advisory opinion has more or less a specialized field of jurisdiction. When it comes to ITLOS, we know that ITLOS is the guardian of UNCLOS. And so for me, it is clear that, you know, ITLOS should be the tribunal that would be the one developing most of the obligations or rights of states regarding regarding the international law which is applicable to climate change in a law of the sea context. When you take the Inter-American Court of Human Rights, the Inter-American Court of Human Rights is specialized in terms of human rights. And so I believe that a lot of the developments regarding, you know, human rights, and in particular the right to a healthy environment and its relationship with climate change or climate change impacts, can actually be the domaine réservé of the Inter-American Court of Human Rights. And then the ICJ, its specialized jurisdiction is general international law. And we know that some aspects of these requests for advisory opinions deal with general international law. So for instance, the legal consequences that are deriving from actions or omissions that have led to climate change impacts. I think that the International Court of Justice is the most appropriate court to deal with those aspects. So if you look carefully, these requests for advisory opinions, each of them has created to a certain extent a domaine réservé for each of those courts. And so I am thinking that enhanced committee should guide the treatment of each of these requests by each of these courts. We know that the International Court of Justice has to deal, for instance, because the request for an advisory opinion on climate change before the ICJ mentions UNCLOS. It mentions the United Convention on the Law of the Sea. It also mentions the obligation to protect and preserve the marine environment. I believe, for instance, that the court there should be as deferential as possible to what ICLOS would say about UNCLOS, about the obligation to protect and preserve the marine environment. And the same for the Inter-American Court on Human Rights. Since the request of Colombia and Chile is referring to coastal states, there wouldn't be any problem, in my view, for the Inter-American Court on Human Rights to give some deference to ICLOS when it comes to what are the obligations or rights of coastal states in that respect. The second aspect I wanted to emphasize, which is a bit a corollary of the first aspect, is, of course, the need for procedural coordination. And I will finish on that quickly, Madame la Présidente. But the need for procedural coordination. It's a corollary of what I call an ENS committee. I think that there is a need for these three courts to engage into some judicial dialogue. Also, this is the judicial dialogue, to engage into some judicial dialogue that would allow them to actually organize how they're going to deal with these three requests for advisory opinion. I think that this would allow any overlaps. This would allow also risk of fragmentation. And so, for instance, nothing would prevent these courts to agree on, a sort of chronology for the rendering of the advisory opinion. So having first ICLOS deciding the request on an advisory opinion on climate change, then the Inter-American Court on Human Rights deciding, and then the International Court of Justice would come at the end of the process and reinforce all the elements of general international law and also build upon what would be said by the Inter-American Court of Human Rights and by ICLOS. So this is what I'm suggesting to prevent any risk of fragmentation and ENS committee and judicial dialogue. But then in conclusion, I believe that, again, the Global South should seize this momentum. And Humphrey, I can tell you that from the African perspective, the African Union is going to participate in the advisory proceedings before ICLOS. So we are talking about 55 states. So we need also to look at the collective approach, not just at the individual one. And the African Union is also going to participate in the advisory proceedings before the ICJ. So this is a huge momentum for our countries. And I think that we can bring on the table very interesting substantive arguments to make sure that the law that is going to be developed is also favorable and beneficial for Global South countries, because it's not just about participating, it's about making sure that the law that is going to be developed by those courts contributes to our needs and contributes to our challenges in terms of adaptation to climate change impacts. Thank you very much.
Thank you very much, Makan, for this speech. It was incredibly interesting. I'm sure there will be millions of questions on your presentation. Thank you very much. Shall we maybe move to the next speaker? Phoebe Okawa, thank you very much for joining us. You are a professor of international public law and director of graduate studies at Queen Mary University of London. You also are an advocate of the High Court of Kenya. You've held visiting appointments at the University of Lille, Helsinki, New York, Berlin, and have lectured for the United Nations at its regional course on international law for Africa. You have acted as counsel and consultant to governments and non-governmental organizations on questions of international law before domestic and international courts, including the ICJ. In 2017, you were nominated as an arbiter to the Permanent Court of Arbitration at The Hague. And finally, you are a member of the International Law Commission. Phoebe, the floor is yours.
Okay. Thank you very much, Isabel, for that kind introduction. And thank you, Humphrey, and the entire Rashmi and the entire organizing team for this invitation. I apologize if my picture and connection is not perfect or is a bit blurred. I'm sitting somewhere in a hotel room in Nairobi, but at least I'm very close to home, which was a good opportunity. And I was actually hoping to come in person, but I'm sure there'll be another occasion for that. We are actually having something of a moment now when we get talking about advisory opinions. In particular, almost all the advisory opinions in one form or another that is now before the court has been at the initiative of states from the Global South. So I know, Humphrey, in your earlier introduction, you mentioned the very limited participation of Global South states in many of the advisory opinions. And I wonder whether, in fact, that may be part issue specific, because in relation to some of the more particularly significant advisory opinions, which have played an important role in the development of the law, I'm thinking here of nuclear advisory opinions, Global South countries have actually taken the initiative in bringing those before the courts, because although the request for the advisory opinion was a General Assembly request, the nuclear weapons case, and the WHO request, the background to it was an organization called Lawyers Against Nuclear Disarmament, which also had a very strong participation by states in the Global South. But it is true that participation, actual participation, leaving aside the question of initiative, and which we're now seeing more where Global South themselves are bringing up these cases, participation has on the whole remained low, and that's not just in relation to advisory opinions. One might even say in relation to contentious cases. It would be interesting to have a much more comprehensive empirical study for this low participation. But one that immediately springs to mind is, of course, international litigation. It's a very costly business. And most African states would, of course, or states in the Global South, would not want to prioritize international litigation, especially when the benefits are not tangible or immediately obvious. The other thing to note is that even when states, including states, the WEOG states or states also who participated in advisory opinions, much of that participation has involved support from their own foreign ministries, domestic lawyers within the foreign ministries, rather than hiring foreign counsel. So there is a question here about capacity. Capacity within our own foreign ministries, attorney general's chambers to undertake international litigation. If you're going to rely on hiring foreign counsel, then that in itself will be a disincentive in a case that's not directly, immediately, and tangibly of interest to you. I think there might be greater participation if you're going to use your own in-house lawyers or domestic lawyers. So there is here a nexus between participation and domestic capacity in matters of international law, in our foreign ministries, in our attorney general's chambers. So that's one perspective I see. So why now? Why this turn to advisory opinions, the surge of advisory opinions. And I think one could argue really that part of it is driven by a frustration in the climate change context with the political processes which have governed the debate so far. We're talking here about the processes of UNFCCC from 1992 right up to Paris Agreement. That although there has been some progress, but it is always a progress where you have 2 steps forward and 3 steps back. We are still nowhere near any concrete obligations. We are still far from resolving the very difficult question of responsibility for loss and damage, and in particular, historic responsibility. So in a sense, the drive to the drive to advisory opinions is in part a reflection of the fact that the contentious option is not a feasible option as well. So one, there's the frustration with the political processes. Those have not delivered. There's been very little progress. The contentious option is not a realistic option, as anyone in this conversation would know. The jurisdiction of international courts are very complex to trigger. It requires the consent of the parties. It requires the ability to essentially identify clear legal rules. And as we know, there are very difficult questions around questions of loss and damage and the centrality of intertemporal law as a principle of international law. So the courts may well say that they cannot adjudicate questions of historic responsibility specifically, or only by reference to the law that was in place at that time. So I think, in a way, Kenya is always a good parallel in which you see this. When you're frustrated with the political processes, when the political processes don't deliver, sometimes you turn to the courts in the hopes that at least the advisory opinion offers a soft landing. The courts will be able to clarify the rules, and in the hope that once those rules are clarified, you can use the clarification as a basis for concrete political negotiation. The other thing is that even if the court renders an advisory opinion, there's always solace for all parties that is not confrontational, because an advisory opinion is not binding on anyone, not even on the requesting organ, at least in theory. But it will spell out quite clearly what the obligations of parties are, and in the hope that once those obligations are clarified, the addressees will change their behavior in light of that advisory opinion. So I think that may be part of the driver why we see many of these advisory opinions being triggered by states from the global south. On the ITLOS one, which again, Professor Mbeng talked a lot about, how the latest advisory opinion, the request for courses came about, an international organization set up just around the time of the COP26 in Glasgow by states that are particularly vulnerable to the effects of climate change, essentially taking matters into their own hands, and again, underlying the frustration with the political process. I mean, how many COPs are you going to have before we get into the crucial question of responsibility for loss and damage, and also who bears that responsibility for mitigation? So COSIS takes the matters into his own hands. And one advantage, again, which I think explains the pathway to advisory opinions, is the simplicity with which you can trigger the ITLOS processes, the ITLOS advisory jurisdiction. Unlike the ICJ advisory jurisdiction, which can only be triggered by requesting organs, which of course would require you to get a degree of political support, either in the General Assembly or in the Security Council, or any of those organs that have a specific mandate to request an opinion. The ITLOS one is essentially quite straightforward. As long as the matter in question pertains to the Convention on Law of the Sea, and the requesting organ has competence under its treaty to make that request, the tribunal will essentially accept that jurisdiction. Of course, it has a discretion not to accept it. But then you can see that COSIS was able to be established within a very short period of time and trigger the jurisdiction of the tribunal. So that partly explains why we see a surge in advisory opinions and the increasing use of that ITLOS process. The other thing to note is again, which is particularly significant, even in relation to the General Assembly request and the ICJ request, which is normally quite difficult because you need a degree of political support. Vanuatu was able to essentially trigger the jurisdiction of the court by getting the support of the General Assembly. Makan talked about the 18 sponsors, some of whom were African states. And in the end, of course, we ended up with a resolution that was adopted by consensus because this is an issue that concerns all. But again, the attraction of the advisory opinion perhaps also lies, its strength also lies in its weakness, because even the sponsoring states know that, well, at most the court will clarify the obligations of parties, but the legal consequences of those obligations will still be left to political processes. So whatever the court says, whether on the question of loss or damage, whether on the question of implications of human rights obligations to future generations, or loss of territory, ultimately, the ICJ will not be the final word on that. It may clarify what those obligations are, but states will still be able to navigate the implementation of those obligations through political processes. So it has an attraction in the sense that if it was a contentious case, as we always say in law, when you go to court, the winner takes all. An advisory opinion is one where you go to law, but the final outcome and implementation of that advisory opinion remains a negotiated settlement, I think, between the parties in question. So that becomes its attraction in terms of it offers flexibility, it offers a self-planning, especially for those states whose responsibility is essentially in question and who may be very reticent to accept the contentious jurisdiction of the court. Of course, the other thing to notice, and I think the speakers before me, both Humphrey and Makan, have talked glowingly about the advantages of advisory opinions and states engaging in this process. But I think there are risks too, because essentially we are trying to ask tribunals to deal with very intractable political questions in respect of which there's been no consensus, in respect of which there's been progress, in respect of which the international community have reached a stalemate, and a stalemate in the face of a lot of negotiation, court processes. So the danger here is, what if the court pronounces on a number of these questions and is ignored through the political processes? It may be that that will actually damage both institutions as a risk. But I think the recourse to court also is because of the stalemate, as I said earlier, on the political processes. It's as if they almost need to be jolted about what those obligations are, and then to create a pathway for their implementation. So it remains to be seen what the possible outcome of these opinions are and what their consequences will be within the international community itself. There was the question which Makan talked about, and others, about the risk of fragmentation and whether or not the proliferation of questions or nearly identical questions before different tribunals may actually lead to conflicting decisions, fragmentation of the law, and in the end, unhelpful for those who will need to rely on these opinions for implementation. I think I'm in agreement too that fragmentation is not a huge risk, partly because the questions asked of the tribunals are slightly different. There's a lex specialis element to the question put to the Law of the Sea Tribunal. It's a very narrow jurisdiction, confined specifically to Part 12 of the Law of the Sea Convention, the obligation to prevent, reduce pollution within the meaning of Article 194 of UNCLOS, and the implications of those obligations in light of greenhouse gas emissions. There is also the much wider question in Article 192, the obligation to preserve and protect the marine environment, which again invites the court to answer that question, what the obligations of parties are, in light of the much wider climate change impacts. So in both cases, this is a very intra-UNCLOS thing. The court is being asked to interpret UNCLOS, a 1982 convention, more than 40 years after it was enacted, and enacted at a time, adopted at a time when there was very little public awareness about the science of pollution. So essentially, UNCLOS is being told that this is not, the treaty is not ossified, it's not set in stone, it's a living instrument, it must be interpreted in light of these subsequent obligations. Because the court's jurisdiction is constrained by that treaty instrument, I think there's no necessary risk that UNCLOS will, rather ITLOS will contradict the ICJ. In a sense, one could argue, and here I agree with Makan, that when the ICJ comes to give its opinion, it should show appropriate deference to the speciality of UNCLOS in dealing with matters that are specifically within the competence of UNCLOS. The ICJ, on the other hand, of course, has a much wider jurisdiction and a competence to consider all the questions put to it within the broad framework of international law, questions of human rights, implications of sea level rise and broader climate change impacts for loss of territory, for questions of displacement and obligations to future generations. So what I see is a process of reinforcement. Each of those obligations, each of those tribunals supporting each other, reinforcing each other, and assisting in development of the law. I don't see it as a risk which will lead to conflicting opinions. After all, the science on climate change is now, it's largely settled. There's a broad scientific consensus on what climate change is and what needs to be done to essentially abet or mitigate the effects of climate change. In terms of I don't know, Makan, I think, has more figures about the participation of states from the Global South. I think the African Union is participating, which is good, because then you have 54 states taking a common position. A number of individual African states are, of course, also taking part. I mean, I've been part of a legal team that was supporting Mozambique and Sierra Leone in the ITLOS advisory opinion. Of course, I think it would be great if more states took part. But there are huge issues here of capacity as well. Almost all of us have worked on these cases pro bono, and it's not that easy to find that many lawyers with legal expertise who take these questions exclusively pro bono. There's also the fact that these questions are complex not just in terms of the law, but complex also in terms of the science. And in almost all cases, we've had to need support from climate scientists to support us in interpreting the science and its application in a legal context. And these are all matters which requires a very clear strategy, a very clear coordination between lawyers and scientists, and very extensive capacity, which I think most African states sadly still don't have. But maybe that's the way where we should have the conversation, essentially, even between now and the ICJ advisory opinions, how we can harness that capacity, how that support can be essentially developed, fostered to ensure more meaningful and generous participation in these processes. But I think I'm going to stop, and hopefully there'll be more questions from the floor, but thank you.
Thank you very much, Phoebe. Thanks a lot for this interesting presentation. We shall now turn to the presentation that will be delivered by Judge Erickson. Judge Erickson served with the United Nations in New York from 1974 to 1977, after which he joined the Ministry of Foreign Affairs of Iceland and served as assistant legal advisor where he participated in the third UN Conference on the Law of the Sea between 73 and 82. He was Iceland's ambassador to Ottawa, then Pretoria and New Delhi. He was a member of the United Nations International Law Commission from 1987 to 96, and a judge to ITLOS from 1996 to 2002. He was a member of Icelandic delegations in numerous international forums, including the Council of the North Atlantic Salmon Conservation Organization, where he served as president from 1984 to 1988. George Erickson has lectured at 40 universities worldwide. He has co-founded and co-directed the International Law and Human Rights postgraduate degree program at the UN mandated University for Peace. He currently teaches law of the sea and international criminal courts at Jindal Global Law School, where he is also the executive director of the Center for International Legal Studies. Judge Erickson, the floor is yours.
Yes, thank you very much, and thanks for being. I thank you all for being invited, and thank you for the contributions which preceded me. I see I'm starting 20 minutes late, so what I was originally going to phrase as caveats, what I was going to say, I'm turning into trains of thought rather, in order to save time. Well, first of all, we're speaking about the global South, and obviously I'm not a member of the global South, but I spent a lot of my time in the global South. And I can just recall that when I was elected to the International Tribunal for the Law of the Sea, a delegation of African representatives came to me and congratulated me and said, "We think of you as one of us." That's one of my proudest moments in my career. Secondly, about this fragmentation. I'm a great believer in fragmentation. I see my colleague and co-teacher in International Criminal Court, Abi Manu, is listening to us. I found nothing but good in the conflicts, you might say, or that what Makanya said was cross-fertilization between cases, courts dealing with international criminal law, and I find the same thing in my own specific sphere in the law of the sea. I'm always tempted to say the more courts, the better. And we went from a time when we had only 1 or 2 courts to a situation we have plenty of options for states to address their concerns, and we see that in the 3 advisory opinions we're discussing today. I am Judge Trevis, who was the president of the Seabed Disputes Chamber. He spoke about a joint cooperative effort, and I think that's we can expect that in the way the 3 courts will be treating the advisory opinions, either formally through some kind of, I cannot see any formal cross-fertilization effort, but I know that they will be thinking of each other when they're deliberating. And thirdly, I should have begun by saying, this is perhaps my most important caveat, I am a climate change skeptic. Now, when I say that, that's a dirty word to a lot of people. What I mean by that is I'm skeptical about the possibilities of the political process, which is referred to by PIBE, solving the problems which are facing us. Somehow we got off on the wrong foot. I was involved in the negotiations for the climate change, fora, now 30 years ago. And I can say that I met just recently a colleague of mine from the Law of the Sea days, who eventually became president of his country. He said to me, "Why did we not have the same spirit of negotiations in climate change as we had in the Law of the Sea?" Now I wonder if it's too late, but in any event, I've spoken about this particular topic, the advisory opinions, recently as a game changer. I see something for the very first time, some hope that we can intervene in the process, not through, as PIBE mentions, the political process, but perhaps the internal judicial process in states. Again, I'm not saying that I have much hope for the way the political process is the results from a political process, the compromises which have to be made. So I'm counting on the judges to do what the politicians have not been able to do. The last time I spoke about this, I began with a presentation from Greta Thunberg. You may know she made a two-minute statement in which she used the term blah, blah, blah about all the efforts which had been unsuccessful, as we heard from our previous contributors here. I look forward to the judges to not speak in those terms, in the blah, blah, blah terms. They have an option now to say something which can make a real difference in this very important field. Thank you.
Thank you very much. It was extremely interesting. Thank you so much. Right, we can maybe turn to the last very courageous speaker, because she kindly agreed to replace Ingo, who unfortunately couldn't join us at the very last minute. So thank you very much, Patricia. Patricia is a lawyer specializing in human rights. She completed a master's degree at the University of Notre Dame. She worked as a lawyer at the Secretariat of Inter-America Court of Human Rights for 10 years. Previously, she was a fellow at the Inter-American Commission on Human Rights, and currently she is a consultant and directs the educational platform Estudia Derechos Humanos. Thank you, Patricia.
Thank you, Isabel, and thank you for this invitation. My idea is just to talk about the advisory opinion pending before the Inter-American Commission, and a little bit about how the procedure is going to be, just like an overall look. And then if there are questions, I will be happy to answer them. First of all, as all of you have already know, this advisory opinion was presented by Colombia and Chile. In the Inter-American system is enough that just one state presents an advisory opinion. You don't need like a consensus like you need it in the International Court of Justice, for example. But here we have that 2 states presented this request for advisory opinion, so that's already an interesting fact. That is not just one, but we have 2 states presenting this advisory opinion, one of which have already presented a request for advisory opinion in the past, in 2017, concerning the environment protection and human rights, that is Colombia. So this advisory opinion is super broad. In fact, it has 49 questions. If you add up all the sub questions that is included in the request, it's just 14 pages long. That if you compare it to previous requests of advisory opinions in the Inter-American system, is quite short, but it still has way more questions than other advisory opinions. And I would like to summarize the questions presented in 6 main topics, but as I said, there are many subtopics within each of the topics, no? So the first topic regards to the state's obligations arising from the duty to prevent and guarantee human rights, and this issue includes issues of climate change mitigation and prevention. So I was seeing there in the questions that somebody already asked about whether this advisory opinion included issues about prevention of climate change and reduction of greenhouse gases. It does. It is in the first main question. I believe in there we can talk about those kind of obligations. Then the second topic is the issues that say obligations arising out of the right to life, and how are we going to understand these obligations, taking into account the science concerning climate change and human rights. So this includes topics such as minimizing losses and damages, access to information, and human mobility. Then we have a third topic regarding differential obligations of states concerning childhood and future generations. So this is quite interesting. This is a super important topic for climate change, and something that the Inter-American Court have not talked about yet, about future generations. Then a fourth topic concerning obligations of consultation procedures regarding activities that have consequences for climate emergency, as well as access to justice to ensure protection and reparation. Then the fifth topic is obligations of protection towards environmental defenders, human rights, women's, indigenous people, and people of African descent. So special obligations concerning vulnerable communities and human rights defenders. And finally, shared and differentiated obligation of states. And this question is quite broad, and it concerns issues such as whether the states have to, how are going to the states repair for the damages caused by climate change. So this is a broad idea of what the request was or is, or what is the request that is pending before the Inter-American Court. However, I must say that there is a huge warning, that is that in the Inter-American system, it is possible that in the Inter-American Court at any stage of the proceedings, even towards the end, right before send or notifying its decision, decides to change or reformulate some of the questions. So the court haven't done that in this case. We still have all these questions pending, but for example, in the advisory opinion concerning the environment and human rights, the advisory opinion that was requested, first, it concerned only the Caribbean. No, Colombia wanted the court to refer to obligations of the states that take part in the Caribbean Sea. And the Inter-American Court said, no, I'm going to answer it more broadly. And that we knew about that decision just when the court issued its decision. So it might happen that the court decides not to answer some of these questions or to mix two questions together. That's something that we don't know and it can change right until the end of the proceeding. So that's one big warning that I wanted to give you. Then also to tell you a little bit about how it's going to be. Normally this procedure, like if you take into account the average time that the court have taken in previous advisory opinions, I would say that this advisory opinion may take about 24 months. So it was presented in January this year. So I will say that it's possible that we have a decision by December 2024 or early 2025. Okay, and one thing that is really interesting about these proceedings is that it is extremely democratic. The Inter-American Court, when it notified that it received this advisory opinion, it opened the possibility for anybody to send observations. Okay, so it sent a specific invite to the states of the Organization of American States, but the invitation is open to anybody. Even individuals can present their observations, and you can do it. It doesn't have to be in Spanish. It actually can be in English and in French and Portuguese as well. However, if I will give you a strategic advice, I would say Spanish or English is better than the other two languages, because more people at the court speak those languages, like French or Portuguese. Now we have a deadline that was set by the court for August 18th, but the court in the past have extended this deadline. So it might be that the court decides to extend this deadline for maybe 2 months more. We don't know. But at the moment, the deadline to submit observations before the Inter-American Court is August 18th. As I mentioned, anybody is welcome to participate. So it will be extremely interesting to see, for example, a participation from the African Union. I heard that the African Union submitted observations to the other two advisory opinions. It will be extremely interesting to receive something like that from states from other regions, because they're welcome. As the invitation is completely open, it will be super important or interesting to see this kind of participation from states from other regions. And lastly, I would like also to mention that in this forum, we have been talking about advisory opinions. However, I think we also need to take into account the three cases concerning climate change that are pending before the European Court of Human Rights, because although there are specifically, there's cases, not advisory opinions, so the topic is more limited. It's still the way the European Court is going to decide those cases is going to affect or may affect the way, at least for the Inter-American Court, might decide its cases. Obviously, it's not that like the Inter-American Court have to follow what the European Court says. Of course not. But it's normally there are very few cases where the Inter-American Court decides something completely different from the from the European system. I mean, the one main difference is that in the Inter-American system, we don't have what the European courts, what the European Court calls margin of appreciation, and that changes the way some of the cases are dealt with. But other than that, most of the case of both courts are quite similar, no? So one other factor, as I was mentioning, is these decisions. It will be, I was hearing some of the panelists mentioning the idea of like creating some kind of meeting from these courts to get together to try to make sure there are not fragmentations and decide which point each one is going to address. That will be extremely interesting, and I don't know if it is possible, but for sure it will help a lot to avoid fragmentation. So that will be the end of my presentation, super briefly, because I just knew about this yesterday, about this panel yesterday. So if you have any questions, please do let me know.
Thank you very much, Patricia. Actually, you do have a question, so maybe there are 3 questions on the chat, so maybe we can start by yours. It's from Janet, and she asks, can international order be sustained without meeting basic claims of climate justice?
Wow, Janet, yeah, and that's a tough question, no? Because it's hard to know what is going to happen, no? When we have, because we already have the effects of climate change present in current times, but we don't know how bad it's going to be, no? So for sure, we might come to a moment, we hope not, but that we're international order no longer the way it is right now. I really hope that we don't come to that, but if everything goes completely wrong and we don't manage to produce greenhouse gases, it is a possibility, but I don't have like maybe some of the other panelists can complement of what I'm saying.
Sure, Phoebe, do you have anything to add?
Well, I would probably say no, it can't, because in the absence of climate justice, and I think this is why the climate justice question has been described as an existential threat. If you think about some of the projected effects, we are talking about mass displacement of populations. We are talking about food insecurity as some of the effects in question, and all this will have much broader political repercussions across numerous societies. So insofar as the present international order rests on some understandings of basic concepts of peace and security, it would be very difficult to maintain things without addressing some of these underlying issues. What are you going to do if we end up with millions of climate refugees in all regions of the world? What if large sections of the world become essentially uninhabitable? Questions of loss of territory, which we haven't addressed. So I think this will have broader implications for global security in different forms and in different contexts. And so my simple answer would be, I don't think the present legal order, international legal order, and concerns about peace and security can be maintained without the inevitability of addressing the questions of climate justice.
Thank you very much. Maybe start with a question that was asked to McCann, and which is the following: how can national courts contribute to transnational climate litigation cases?
Yes, thank you. Thank you very much, Madame la Présidente, and thank you for the question. Well, I'm not sure that I can give very, very clear, solution on how national climate change litigation can contribute to more transnational climate change litigation. But if we come back to the context of the request for advisory opinions that are presently before the ICLOS, the ICJ, and the Inter-American Court of Human Rights, I think that in my view, it will be inevitable for these three courts to actually look at state practice. I think that some of the questions that have been raised in the context of those advisory opinions would require careful examination of state practice. You know, I speak under the control of Patricia, but for instance, in the context of the Inter-American Court of Human Rights, if you want to determine, I believe, how to interpret human rights obligation under the Inter-American Convention in relation to climate change impacts, the court will have to a certain extent to look at what is the practice of many Latin American states and Caribbean states, and the court did it. The Inter-American Court did it actually when it rendered its advisory opinion on the relationship between environment and human rights. It looked at state practice and in particular at the constitutional practice of states. So in my view, national litigation, climate change litigation, can actually inform what could be developed by these three international courts. We know that there has been some very important, significant developments before domestic courts. If you just take the example of the Urgenda case in the Netherlands, the Dutch courts, they really contributed, you know, to clarifying certain obligations when it comes to climate change mitigation in particular, but also issues such as, you know, applicability of precautionary approach or precautionary principle in the field of the fight against global warming. So I definitely consider that cross-fertilization with domestic courts and with what has been said by those domestic courts in the context of climate change litigation can actually inform the interpretation of international law before these three international courts. Thank you.
Can I add to this, Isabel?
Yes, of course.
Because I'm very fond of this term, this cross-fertilization, and I would add also a renvoi, because I can see the opposite. The trouble with some national courts, the problem that some national courts face is the very questions that are being asked have not been answered, I see a case now in Sweden, which can be informed by results from the international court. Now, those who argue that no damage is being caused or no liability is being caused, is incurred for damage being caused, they say, well, look at the international system. And then they point to these agreements and so forth, very general and so forth, and nothing, as we've heard today, about liability. When I was in the Law Commission, we dealt with the topic of international liability for damage caused by acts which are not internationally unlawful. Well, we've gone past that stage now. And I ask you, I ask anybody, I ask my students when I speak, if somebody dumps something, if your neighbor in your town dumps something into your territory, into your lot, you have a legal action against him. Why don't we have that in international law? And that's the problem with the negotiations, the way nations negotiate amongst themselves. And this is why I'm hopeful that when the judges intervene in this political process, introduce things into that political process, we will get more results than we have in the past 30 years.
We have another interesting question to all panelists. Is the following: are climate change negotiations inherently disadvantageous to the global south? I don't know who would like to answer this one.
Let me jump on that. You know, it's a very good question, of course, and I'm not sure whether we should think about advantageous or disadvantageous. I think that if you look at the history of climate change negotiations, developing countries and global South countries have been to a certain extent successful in, you know, making sure that climate change negotiations take into account their concerns. Let's not forget that now the objectives under the Paris Agreement is not just about mitigation, you know, it's also about adaptation. If you take Article 2, Paragraph 1 of the Paris Agreement, it talks about, you know, little a, mitigation, but little b is about adaptation, building climate resilient societies. Little c talks about facilitating financial flows. If you take those two last objectives of adaptation and facilitating financial flows, these are concerns, these are needs that have been pushed forward by the global South, not by the rich countries. The rich countries, of course, they would like mostly to only focus on mitigation, and that's it. So it is there as part of the objectives of the Paris Agreement. If you think about a mechanism like the Warsaw mechanism on loss and damages, the whole issue of loss and damages is actually something that has been pushed forward in climate change negotiations by the global South, by developing countries. So we can't say that the architecture of climate change negotiations do not take into account the concerns of developing countries. I think that where the challenges are, it's in terms of implementation. How, for instance, do we make sure that climate finance is more a reality than a myth? You know, rich countries have been promising billions and billions of dollars since 2009 at COP15 in Copenhagen for the Green Climate Fund. Well, billion and billion dollars that are supposed to fund adaptation, that are supposed to fund green technologies, et cetera, and we are still waiting for the money. So this is a problem. I think the problem is really in terms of implementation and having rich countries complying with the commitments, the financial, technological, technical commitments they made. But this allows me, Madame la Présidente, to jump quickly again back into what we are discussing today, which is the contribution that these requests for advisory opinions can make. I finished my presentation earlier in saying we need to make sure that what is going to be decided by these courts is beneficial to the global South. And for me, I don't think that, you know, the global South should just say, oh, we want ITLOS or ICJ or Inter-American Court of Human Rights to tell us what are our obligations in terms of mitigation, adaptation, etc. What we want is also, you know, clear indication of our rights. What are the rights? What are the rights that developing countries have, you know, in the context of climate change, in an era of climate change? And I'm very much hoping that all these three courts will actually emphasize, you know, what we call common but differentiated responsibilities. CBDR, common but differentiated responsibilities, is at the heart of the climate change regime. And we need to make sure that whatever is going to be developed by these courts takes into account the asymmetry that should be applicable when it comes to the fight against global warming and when it comes to adapting to climate change impacts. You know, dear Isabel, I was sitting recently in an expert group where we were discussing trade and climate trade-related measures, where some of the colleagues for whom I have huge respect, some of the colleagues coming mostly from the rich world, are actually contesting that common but differentiated responsibilities is a principle. Is a principle when it comes to the international law applicable to climate change. And for me, if I'm sitting in an expert group where people are saying that after more than 30 years of climate change negotiations, this is problematic. So I really hope that these advisory opinions will have this developing country flavor, this global South flavor, to allow, you know, our countries to adapt once again more easily to climate change impacts. Thank you.
Maybe one interesting question about Global South from Nicholas. It was delivered on the chat during Phoebe's presentation. Is the following. Isn't Global South a stilted category for this analysis? Nicholas says, Chile and Colombia are among the wealthiest countries of South America, and their request is very South American specific. Isn't fragmentation already there then?
Thanks, Isabel. I'm not sure what the question is. Is the question asking that the Global South as an umbrella term embraces countries at very different levels of economic development and that it's too broad to be useful? In a sense, yes, but I think there is an element of solidarity about having an umbrella body with states, and much of this is history, much of it is questions of states who want to see progress on particular issues. I don't think there is any assumption that this is a homogeneous group who are all at the same stage of development, but it's also a question of having a shared perspective, some shared histories of colonialism, of marginalization, of inequality, of being outside the system and wanting to change that system. So I agree, but dividing groups within a Global South is in itself a recipe for disaster, because some of the progress that have been made in the climate change regime, some of which Makan alluded to, from 1992 UNFCCC right up to Paris, has been the result of the Global South as an umbrella group having a uniform position on a number of questions, hence the centrality of common and differentiated responsibilities, the centrality that due diligence must reflect questions of historic contribution to the climate change damage. So in a sense, if you divide the group, what you'll end up with is each segment of Global South negotiating in their own narrow interests. And once it's divided, then those who have contributed the most, questions of historic responsibility will go out of the window. So I don't see the uniformity is in itself as a problem amongst groups who were diverse in terms of levels of economic development. And in fact, the climate change regime reflects that. But I would say that there's no necessary harm, especially when we are at a stalemate on many of these issues around climate justice, to start looking for fragmentation within the Global South. That's not the way to make progress. And I think the climate change regime already accepts that within common and differentiated responsibility. Concepts of due diligence are based on state capacity. But as a political tool, I think there's so much strength in solidarity and having a common position.
Yes, Makan.
Yes, very, very quickly, I totally agree with what my dear sister and colleague, Professor Okawa, said. But I think that the question is very excellent and very thought-provoking, but I think we need also to contextualize things. As Patricia was mentioning, the request for an advisory opinion on climate change in the context of the Inter-American Court of Human Rights was made in the context of the Inter-American Convention on Human Rights. So it makes sense from a procedural point of view that the request is insisting on Latin American countries and on Caribbean states, because the Inter-American Convention on Human Rights is not applicable to African countries, is not applicable to European countries, is not applicable to Asian countries. So I think that from a legal point of view, to make sure that there wouldn't be issues of jurisdiction, because remember that advisory jurisdiction is never granted. It's never granted. An international court can come and say, well, the question is not legal, or this falls outside my jurisdiction, etc. Or there are aspects that should push the court not to decline to respond to the question. So we should always be careful with these things that can happen before an international court. And so that's why I think it's important to craft very carefully those requests. And I think that this is what Colombia and Chile have done. But then when you look at the case law of the Inter-American Commission and Inter-American Court of Human Rights, I think that it is not a case law that is, you know, that is calling for fragmentation. Again, a careful reading of the advisory opinion of 2017 on human rights and the environment, when you read that one, you will see that the Inter-American Court of Human Rights not only referred to universal courts like ICLOS, like the International Court of Justice, but also referred to the European Court of Human Rights, referred to the case law of the African Commission of Human Rights and of the African Court of Human Rights. And so I know that Judge Goodmundo likes the all cross-fertilization, but again, what we've been seeing there was really cross-fertilization in the consolidation and crystallization of case law relating to the international law applicable to environmental protection. So I am optimistic. I am optimistic that, you know, the Inter-American Court of Human Rights will go and actually check what has been developed elsewhere to inform its legal reasoning, its legal arguments in its advisory opinion. So I want to stay optimistic and believe that there will be more harmonious development of able to climate change advisory opinions rather than fragmentation. Thank you.
I think it's time, unfortunately, to wrap up.
Isabel, can I make
yes, I was about to give.
Can I make a closing anecdote? I know Lakshmi
Yes.
is groaning, but this is what we just heard. In preparation for the Rio conference, 1992, there was a process of developing something called Agenda 21. I was involved in that process. At one stage, when the documents were being presented, I said, listen, why don't we stop wasting time? If anybody makes a proposal which actually means something and requires some obligation, just raise your hand. Anyone else can raise their hand and we'll take it off the table. Well, I got some support for this, and I had to intervene again to say that I was being sarcastic. But I'm so happy now. So I'm saying west, south, north, east, all states go out of their way to avoid obligations in this kind of forums that we're discussing. And I'm so happy that all of us, and on a positive note, that we can see some future away from that process.
All right, thank you very much to everyone. It was such an honor to moderate this webinar, and I'm sure that all the speakers were delighted to be here. I understand that the second part of this webinar will take place on 30th of August, 2023. We all look forward to it. Thank you very much. Would Rashmi or Humphrey give a final word?
Yes, Isabel, it will be an honor to give a vote of thanks. Again, my heart is overflowing with appreciation. It's been a fascinating conversation. Time has flown quickly. Maybe one of the lessons takeaways is to have a 2-hour conversation the next time, so we can pose more questions. Most thankful to all the panelists, to my teacher, Judge Erickson, to my supervisor, former supervisor Patricia, to Prof. Okowa, to Professor Mbengwe, and to colleagues from AFSIL and Jindal. Thank you so much for putting this together. To all our attendees, beginning with Patricia, who's woken up quite early in the day, to those who may be in the Far East and have stayed up late. We're most thankful for your attendance and for your participation. I'd like to mention again that we are keen to see that this process also produces some discourse that can be referred to. As teachers of law, we're quite keen to ensure that we build the knowledge base necessary.
Looks like we lost Humphrey there for connectivity issues. I'm just going to jump right in, try and finish his thought, because I think I know what he was going to say. We do hope that there will be some written comments and observations that we will be able to generate from this webinar, and the second one on the 31st of
our
August.
students to jump to that level of X2. And so I think that's really the main things. To again, to maybe whoever may be from the academia out across, and to any state officials, we hope this has been inspiring, and we look forward to further conversations, as clearly there's much that can be submitted, including to the Inter-American system. So everybody, thanks. I don't know if Rashmi had one more thing to say.
No, it was Zoom, Humphrey. You cut in and out. So yeah, clearly we are being thrown out of here by Zoom.
Yes, it was just more appreciation to everybody. Thank you so much. Let me leave you the quite final one line from my Law of the Sea teacher, who happens to be here. He once said in our class, hard cases make bad law. Are any of these three cases hard? And will they make bad law? Maybe a conversation for 31st of August. So we look forward. We'll keep the information available on our social media handles. And yeah.
Thank you to Isabel for fantastic moderation.
Yes, for sure.
Everybody. To African Society for International Law for the forum, to Professor Makanim Benge, Professor Gudmundur Eriksson, Professor Phoebe Yokowa, Patricia, Isabel, Humphrey, John Nyanje, to everyone from where I am, good evening, good night, and to the rest of you, wherever you are, have a great day. Bye-bye.
Thank you
very much.
Bye. Congratulations.
Thank you. Congratulations.
Bye-bye.
Thank you.
Bye.